Hello, I'm Los Angeles City Controller Ron Galprin. As our city's Chief Financial Officer and watchdog, it's my job to help assure public dollars are being put to good use by keeping our government honest, responsive, and accountable. Because people want to know and deserve to know how their money is being spent. And just as it's important for the city to plan how to use our money wisely and make good investments, it's just as important for every Angelino to do the same. Because the financial health of our city, of our communities, depends on the financial health of every Angelino. Financial literacy and financial planning for individuals and families is crucial to success, and so is making positive financial choices for today and for the future, so that you can get bills paid, make the rent, save up for a car or a home, further your education and that of your loved ones, retire, plan for trips and vacations, and so much more. I want to thank so much our outstanding LA City Library and its leadership, including Chief Librarian John Szabo. Thank you to all the staff and the volunteers, notably our certified financial planners, and the library's Department of Lifelong Learning and its partners. And thank you for ensuring everyone has the tools and resources necessary to plan, save, invest, and manage their finances for the future, for their family's future, and for our city's future. To help with this, I would encourage you to check out my How to Build a Financial First Aid Kit tool, which gives you information you'll need to be prepared in case of an emergency. And you can find the kit at lacontroller.org/financial First Aid Kit. I wish you a positive and fruitful day of financial planning, and thank you all for participating.
Everyone, my name is Deborah Spector, and I work for the Business and Economics Department at the Los Angeles Public Library. Welcome to Financial Planning Month. Today's presentation is called Estate Planning, Getting Your Financial House in Order, and is part of a month of programs in support of financial planning. Today's program is brought to you by the Financial Planning Association and the Los Angeles Public Library. Certified Financial Planner Amy Bourne from the Financial Planning Association will present today's program on estate planning. She will describe why you need an estate plan and highlight some of the basic components of an estate plan. Please submit your questions throughout the program. We'll be able to answer them in the chat, and we'll have time for a brief Q&A at the end of the program. Thank you very much for being here, and passing it to you, Amy.
Thanks, Deborah. Good afternoon. It's a pleasure for me to be here today. Thank you so much for attending. As Deborah said, my name is Amy Bourne, and I'm a member of Financial Planning Association. Financial planners work with clients in a broad array of issues, including estate planning. Today, I'd like to share with you some important things that you need to know about estate planning, whether you're just starting out, beginning a new estate plan, or you're revisiting one that's existing. I hope to answer your questions today. What we'll cover, some key elements to estate planning. Estate planning is obviously an essential part of the overall financial planning process, and then some basic planning tools. Estate planning can be very complex, so we'll only be able to touch on the highlights today. But before we get started, I'd like you to ask yourself some of these questions. Have you ignored planning for retirement? Have you postponed saving for college? And have you put off estate planning? You're not alone, but think about why you are procrastinating as we go through this process. According to care.com, a question for you: what percentage of adult Americans have a will or a trust? You can pop in the chat what your answer, what you think the answer is. And this was a survey that was done in 2020. So the answer is, in fact, 32%. So only 32% of American adults actually have a will or a plan in place. And this is actually a decrease of 25% from a similar survey that was done in 2017. Why do you suppose some of these people are putting this off? There's a multitude of reasons, and we'll talk a little bit about why people put this off. Some of the reasons are they don't believe they have an estate. They don't think that their estate is big enough to have an estate plan. There are family issues. How do you choose between your kids in terms of what they are going to inherit or other people in your lives? Other issues are too much complexity. For people with large estates, this can be complex, but there are experts that can help you through this process. For others, estate planning can be simple as getting a few basic tools in place, and people don't realize that. Some people don't do the estate plan because of the costs. It costs money to hire a financial planner or an attorney to help with an estate plan, but the money that you spend today could be far less than your heirs could bear if you don't have an estate plan. And then just reluctance about dying. It's only natural to want to avoid facing our mortality. We all hope to have long, happy, healthy lives, but obviously natural disasters and events like 9/11 shake that up and help us question if we need to put together an estate plan, and it adds stress. So let's talk a little bit about estate planning and what it involves. The first part is getting an inventory of your financial assets. So basically writing down or putting in some sort of spreadsheet what you own and what you owe so that you have a clear picture of your overall financial situation. And then that would include obviously your home and other real estate, and then also personal properties like cars, also retirement plans like 401ks and IRAs. And then lastly is insurance, making sure that you understand your life insurance, what amount that you have, and that would obviously go into your estate. Let's talk a little bit about the benefits of estate planning. The benefits are that you determine the disposition of your assets as opposed to the state. Each state has their own laws in terms of how they would distribute your assets if you don't have a plan. But if you do have a plan, it's your instructions that will be followed. Another benefit is that you can pass on wealth to others in your lives that are important to you that may or may not necessarily be next of kin, which obviously the state would not understand. You can enrich your favorite causes or charities within your estate plan, and then also minimize probate. You can avoid or reduce the costs and delays of probate, which can be a very lengthy process. It's a legal process of approving or validating a will. If no one exists in determining the distribution of the deceased person's property, the will detect it, or the state will tell where those assets go. And the last is reducing estate taxes. Most estates are not subject to estate taxes, and we'll see a little bit later how those levels work in terms of estate taxes. But that is one benefit, obviously, with having an estate plan in place. So what happens when you don't have an estate plan? As I discussed, the state of California, if you're in California, obviously has a plan for you You have no control over that plan. And then some heirs, may be left shortchanged, and that may not be your intention. The second thing is that probate can be costly and take a very long time, because obviously it's a governmental process. Estates usually pay potentially higher taxes, which we can look at a little bit later. And then family disputes may occur. Of course, wills can be disputed too, but without some sense of clarity, quarrels may happen within your family. So having an estate plan can prevent that. And I wanted to talk a little bit about what, before we get into taxes, there are estates within California that can go through a more expedited process. It's estates really under $166,000. You can go through the courts, and if we can list that. Thank you. The California courts, a simplified process to transfer estate. If you Google that, you can go through and see if your estate plan can be going through this simplified estate process. And then we'll move on to estate taxes. So estate taxes really affect a pretty small percentage of the American population. If you look historically, what the amount is that you can pass either by gift or by estate, meaning at your death, since 2011, it's come up pretty dramatically with some of the tax law changes. So in looking at this chart, you can see in 2011, the amount that you could pass is around $5 million without estate taxes. And that went up with a little bit inflation adjusted adjustments through 2017. And then you can see in 2018, we had a substantial tax legislation that passed, and we can now transfer about 11.6 million to heirs without paying estate taxes. If you go over that amount, then the estate tax rate, that means the amount that the federal government takes of that amount you transfer, is 40%. So that means that 40% goes to to the IRS, and then 60% goes to your heirs. So if obviously that's a significant tax. If there aren't any changes to the tax law by 2025, this law will actually revert to previous law, which means it will drop back down. You could see the line going up to the right side. It'll go back down to that sort of $5 million inflation adjusted amount. So many more Americans will see possible estate tax implications in 2025 if Congress does not act. The other thing that you should note is the annual amount that you can gift to anyone without being subject to estate taxes is $15,000 per year. And some people get a little confused. If I transfer $20,000, do I actually pay estate taxes? Well, the answer is no, but you do have to file a gift tax return. So that means if you transfer $20,000 to an individual in any one particular year, that $5,000 over the annual exclusion of $15,000 will actually get credited against this $11 million that you have free to give away. So people get confused thinking that they owe taxes when that happens, but no, they just have to file a gift tax return and show that they've kind of eaten into this amount that you pass estate tax free. So let's talk a little bit about the estate planning process. We like to break it out as financial planners into 5 different steps. The first step is to set your goals. The second step is to evaluate your situation. The third step is to develop a plan. The fourth step is to take action or implement that plan. And the fifth step is to monitor and adjust your plan along the way. So let's drill down a little bit into these different steps. So in terms of setting your goals, the order of importance varies, obviously, based upon your situation. If you're a parent of a young child, your primary concerns may be providing the everyday wants and needs of your child, meaning who takes care of your children if you were to pass, and then maybe setting aside enough money for college or private school needs. If you've remarried, one of your goals may be to leave an inheritance to your children from your first marriage. That may be an important situation, because if you remarry and then you die and you leave all your money to your new spouse, your kids from your first marriage may not be able to benefit from your assets. If you have a child with special needs, providing his or her needs may be at the top of your list, and there's special ways that you can plan around that. And then on the other hand, if your primary commitment may be to a friend or a charitable organization. So it's a matter of sitting down and trying to figure out where you'd like the assets to go and who you would like to help. Step 2 is evaluating your situation. So the first step in terms of evaluating your situation is to make sure that you have a good inventory of all your physical and financial assets. That is to make a net worth statement, or also called a balance sheet. So this means compiling a written record of everything you own. You don't have to evaluate your, small collectibles that may or may not be worth a lot of money, but you should write down some of the more meaningful assets, such as personal property, real estate, retirement plans, the face value of life insurance policies, and things like that. Next, determine how your assets are owned. Are they owned in your name alone? Are they in retirement assets? Are they jointly held with another person? So make sure that you understand the ownership of all your assets. There are things that may be part of your personal estate and that you have the right to transfer without going through probate. And a lot of those are anything with a beneficiary designation. For example, a 401k account, you just have to put down a beneficiary, and that asset will transfer outright to the beneficiary on that retirement plan, and it actually avoids probate. Another way to transfer assets in your own name is what's called a transfer at death, TOD or POD, pay at death. So if you have a bank account that is in your name alone, you can go to your bank and assign a beneficiary to that account so that it gets paid directly to the beneficiary at your death. And typically the only requirement would be for them to show a death certificate and obviously appropriate ID. The other things you want to put down is any debts that you owe. So credit cards, your mortgage, your car loan, making sure that you have your account numbers, the financial institution listed, so that it makes the job of your heirs easier, so they know where everything is. Some special situation that you want to take note of is, many people have situations that that are different and unique, and you want to make sure that you're thinking about this as you put your estate plan together. Children is from a previous marriage. We talked a little bit about that. Special needs children, that's critically important to make sure that, you put together a special needs trust so that that child can continue to qualify for, federal benefits through, the Social Security Administration and things like that. And then business partnerships. You want to make sure if you have a business partner, and your half obviously goes to your spouse may not understand how to run the business, that you have some sort of agreement, either a buy-sell agreement or something in place that that your business partner has the liquidity to be able to take over the company, and maybe your spouse doesn't want to take over the company or be in that situation. And then also any family heirlooms. So any collectibles, jewelry, anything that is important that you want to make sure is passed on to a particular heir, you can actually outline that in your plan. The third step is to actually develop a plan. So you can start with a financial consultant, but at the end of the day, you'll need to bring in a legal professional to actually draft the documents. Financial planners can help assist in terms of educating you on the different components that are important in the estate plan. But at the end of the day, you'll need a legal professional to draft the documents. Secondly, evaluate the various estate planning tools and what's going to work best for you. Typically, you want to start with a will, and then in terms of having a living trust, that depends on your situation and whether or not that makes sense in your situation. But everyone definitely should have a will to start with. So let's talk a little bit about the sort of 5 components of an estate plan that are very important in terms of your sort of your basic toolkit. So starting with a will. A will is a legal document, and they vary. The laws are state specific. So it's very important if you move from one state to another that you update your will according to those states' requirements. It's a listing of your heirs and your bequests. So that means that you'll list all the people within your estate plan, and you can specifically say how much is going to each individual, either in percentage or dollar terms. You'll also name a personal representative, or what's also called an executor, and that person will be responsible for implementing the will. So presenting the will to the courts, and making sure they distribute the assets according to the will. And then those people that have a minor children, a very important part of a will is to identify guardians for your minor children. They may or may not be the same person as executor. It depends on if you think that the person could be the executor, so making those financial decisions, as well as taking care of your minor children. So that's a very distinct decision that you need to make as you go through the process. What's not included in a will? That would be anything that has a beneficiary. So what will not be included in your will is anything that doesn't have a beneficiary, because Any assets that have a beneficiary designation will transfer according to the beneficiary designation at that financial institution. So the will not be relevant in this case. So any jointly held property, so if you have joint tenant, brokerage account, the second joint person would be the person that takes over that property, and it will avoid the will. In a situation where maybe you have a husband and wife and they pass away at the same time, then there's no beneficiary there because both of them passed away. Then in that situation, it would go through probate or through a will. Retirement plans will also avoid being in the will or probate because they have beneficiary named on the accounts. And oftentimes you'll see a beneficiary, a primary beneficiary, and then you can designate secondary beneficiaries. So if the primary beneficiary passes, then the asset will go to the secondary beneficiary as listed on the account. Also, insurance policies. Insurance policies have a beneficiary designation, so that would avoid probate or the will, going through the will. And then, obviously property that you no longer own, either you transferred in the trust or you've given it away, obviously would not be included in your will. Another document that's important is a living will or advance directive. So a living will outlines your wishes in terms of life-sustaining medical treatment, so pull the plug or not. And a written and witnessed document is usually required. So this document should be prepared by a legal professional and obviously executed properly. When you do execute an advance directive, it's very important to tell your family or loved ones. So if you have 3 children and you've picked one of the 3, make sure that all 3 of them understand what your wishes are. And then also you'll want to file a copy with your doctor and obviously your family members. A lot of hospitals will have you actually sign these, when you're admitted to the hospital and that sort of thing. But if you have it in advance, you have it, with you, have an electronic copy that you can save in the cloud, you'll have it available for you, obviously, and your family. Another document that's important as part of this overall estate plan is powers of attorney. So there's 2 different powers of attorneys. There's one financial, and then there's healthcare. And this may or may not be the same person. So in terms of financial powers of attorney, they take over any financial matters for you in the event that you aren't able to, because of a disability or some sort of maybe temporary or permanent situation that you're not able to handle your financial affairs. Powers of attorney can be changed at any time. If you obviously change your mind in terms of who you want as power of attorney, you can do that at any time. The second is the healthcare directives. So this authorizes any end-of-life wishes and obviously can be changed or revoked. But this person can handle any decisions that are made between, about you and your healthcare when you're not able to. So let's talk a little bit about trusts. Not everyone has trusts, but it is a legal document that you need to obviously draft with a professional lawyer. And there are many different trusts that have different purposes. But the most common would be what's called a revocable trust. So that means that you can revoke the trust or change the terms of the trust anytime during your lifetime. And then there's other trusts called irrevocable trusts. So that means that once you set up the trust, it can't be changed in the future. And those typically have different tax ID numbers and add to a little bit more complexity. But the benefit of a trust is that it avoids probate process. So you'll be able to present the trust to the courts, and anything within the trust is private. As you know, when you have a will, you're listing the beneficiaries, how much they get, and all that is public record. But if you have a trust, the will basically just says everything goes into my trust and it stays private. So not only private, but it avoids the whole probate process. So the probate process can be costly, 3% of your estate in attorney's fees, and it could be lengthy. So if you want to avoid that for your heirs, you can set up a trust in addition to a will, but you'll need both. And then in terms of gifting to others, here we talked a little bit about gifting during your lifetime. This is a little different than gifting at your death. But as you can see right now, you can gift up to $16,000 per recipient per year. That's up from $15,000 last year, plus an additional almost $12 million now during your lifetime. Obviously, most people are not going to be in that category. But if you do gift more than $16,000, again, anything over the $16,000 would just go as a credit against your lifetime exemption of $12 million. All gifts between spouses are tax-free. So you can exchange, obviously give gifts between spouses. There's no tax implications. But that is assuming that both spouses are U.S. citizens. There are limits if one spouse is a non-U.S. citizen. And then in terms of bills paid directly to medical facilities or educational facilities like colleges or private schools, that is unlimited. So if you're sending your child to college and you're making the checks directly to the college as opposed to going through your child, that avoids cutting into your unified credit that you can give. So in terms of taking action, so you have your plan in place. If you don't take action, then obviously the plan doesn't do you any good. So some of the important things that you want to do is make sure you take action. So in terms of choosing the tools that you use, make sure that you have a will, you have powers of attorneys, possibly a trust, you have that in place. Decide on who your heirs will be, so the people that will receive your assets at your death. Your executor of the will, so that's the person that represents you to the courts, and then your trustee. So in terms of a trust, usually during your lifetime, you're your own trustee, but at your death or disability, you may have, obviously you will have successor trustees that can come in and facilitate any financial decisions within the trust assets. And then powers of attorneys, both and financial in case of your incapacitation. You'll want to execute, obviously, the required documents. An attorney can help you with those execution of the documents. The fourth item is very important, is if you do put together a trust, you'll want to assign or retitle any assets into the trust name. So for example, if you have a house that you own, and you own it in joint tenancy with your spouse, you'll actually want to file a quitclaim deed with the courts. You retitle that into your trust name. And then obviously buy insurance if you're working and you have one spouse working and the other one stays home or works and earns substantially less than the other, you want to make sure you have insurance to replace those potential earnings in case of death. And then one important thing is in case of your disability. So if you became disabled, you could have a disability insurance to replace that income. And then communicate your intentions to your heirs. Make sure that they understand what will happen in case of your death so that there are no confusions in place. We talked about this a little bit, but there are different types of insurance. There's insurance that will protect sort of your assets. So that would be homeowners insurance, auto insurance, renters insurance. There's also liability insurance, and you can get obviously what's called an umbrella policy that, like an umbrella, covers additional liability insurance for homeowners, renters, or automobile in case there's a situation where they're suing for more than what your insurance policies cover. And then the other type of insurance is to protect your financial security with either life insurance or disability insurance. So with life insurance, this would be covering sort of your everyday spending costs, maybe setting aside amount to pay for college or pay off a mortgage, and then maybe to even provide an inheritance if that was important to you, or with a business partner. If you have a business partner, it will allow your spouse to buy out, your business partner to buy out the spouse, so that they have the money to be able to continue to run the business without you. And then, of course, disability insurance, what we talked about. So in terms of communicating, you'll want to make sure that you talk to your heirs, maybe sit down with them and talk about that you've put an estate plan together, and that you've designated an executor and named that executor or successor trustee. And if you're not comfortable talking to your heirs about the situation before your death, you can always write a letter of instruction and keep that with your attorney or keep it with someone you trust, that can be obviously read upon your death. Make sure to discuss these wishes before your death with any executors that you assign or trustees that you sign, just to make sure that they agree to do this for you, because obviously it can be a big burden and an important process. There's also financial institutions that will do this for you, be a successor trustee if you aren't comfortable with asking a friend or your adult child to do these steps for you. So those are some of the things that you need to think about as you sort of walk through that process. So if you do write a letter of instruction, you'll want to make sure that you have some things in that are included. You want to make sure that you're clear in terms of what your final wishes are. You want to make sure you identify the location of any relevant documents. For example, if you have a safe in your home or if you have a safety deposit box at a bank, you'll want to make sure that your heirs know exactly where those documents are. If it's on the web, you'll want to make sure that they have access to your digital assets and things like that. And then important context names. So your estate planning attorney. So that person will usually will have a copy of your executed will and your executed trust in case you can't find it. Financial planners tend to keep these documents as well as sort of a backup. Accountants, any insurance agents, and any bank contacts. You'll make sure you have their contact information and phone numbers readily available. And then obviously, if there's anything specific that you want to outline in the instructions in terms of your funeral or where you're, want to be buried, that sort of thing, you can include those sorts of things. In terms of working with a financial planner, oops, I skipped it, sorry. I skipped step 5, which is an important part of the financial planning process. So after you've implemented your estate plan, you want to make sure that you update it on any major life events. So in case a spouse passes away, you get divorced, you have another child, or even a grandchild within your family, you want to make sure that you update it accordingly. Any new financial situation, for example, you receive an inheritance and it changes your financial situation, you'll want to make sure you update it. Any moves between states, again, these are state documents, so you want to make sure that your estate plan reflects the state laws for which you live. And then any updates for tax laws or legal changes. Generally, you want to update your estate plan maybe every 5 to 10 years, depending on what laws have changed over time. In terms of working with a financial planner, financial planners help you with sort of a big picture. So it could help save you time in terms of working with the attorney because you've thought through some of the important decision points that you have to make. For example, selecting executor or successor trustee. Personalized advice. Financial planners generally know your entire financial picture and can help with working through what types of trusts might be appropriate to talk to estate planning attorneys for. They also could be a good resource in terms of providing referrals to estate and trust attorneys. And then obviously assistance with helping you, understand the documents, and then obviously keeping you abreast on any changes that you may need to take into consideration. So to recap what we covered today, we talked about setting your goals. What are you trying to achieve? Who is it that is important to you and that you want to make sure are taken care of? Then evaluate your situation, take an inventory of your assets. Remember putting together a net worth statement and understanding some of those special situations like remarriages or children with special needs. Develop a plan, so working with a professional and getting those tools and documents in place. Taking action, that's actually executing the documents and making sure that you inform your loved ones and making sure that they have copies of the documents. And then lastly, monitor and adjust your plan as your situation changes. So with that, we can go to any questions that we have in the queue. you could just type them in and ask, and we can answer them. In terms of resources, you can go to plannersearch.org to find a planner in your area that specializes in different aspects that might be important to you. And then obviously, thank you for your time. We appreciate your time today, and hope you have a great rest of your Friday.
Great, Amy, thank you so much for such an informative presentation. This will really be helpful for people as they kind of prepare for their future and the future of their families. A few questions did come up.
Okay.
The first one we want to, if you could answer, is what is an estimate for how much it costs to prepare an estate plan, will, or trust?
That's a good question and can vary. It can be as inexpensive as $400 or $500 through a company like LegalZoom, online company. Obviously, you need to make sure that you're tech savvy, or somebody who can kind of work through sort of an online platform if you're comfortable with that. If you're hiring an attorney, generally, wills, just a basic wills, maybe around $1,000. If you're looking for trust too, it could be, $3,000 to $5,000. So that's where you get into the more expensive, area if you have that one-on-one attorney that's working with you. So that's generally. But if you want to start inexpensive, there's those online tools like LegalZoom that can help you with that.
Oh, excellent. Great. Thank you for providing the different options that people can pursue for that. The next question is, does it count if I've written my will on a piece of paper at home?
Yeah, it does actually. You have to have your signature, and it's called a hylographic will. It works, but it has to be handwritten. It can't be typed up, so you actually have to write it all in your handwriting. But yeah, that can be. It's not ironclad, but it definitely can be presented to the courts. And it could be a valid will, but again, you have to sign it and write it in your own handwriting.
Okay, great. Thank you. And we have a third question of, can you explain more about what probate is and why it is something people might want to avoid? You've mentioned it throughout as something that has a cost and such, but can you explain more actually what it is?
Yes. So probate is the legal process to distribute your estate. So what happens is if you don't have a will, the government has one for you. So they decide where those assets go. And typically the way it works is if you have a spouse, then everything will go to your spouse. If you don't, then things will go to your kids. If you don't have kids, then it goes up to your parents. And then if you don't have parents, then it goes kind of sideways to your siblings. That may or may not be the way you want it distributed, but the probate court will tell you to do that. It also costs roughly, attorneys that are probate attorneys will charge a fee to go through probate, and that can be up to like 3% of your estate. Mm-hmm. So it could be very, very expensive to go through probate. If you have an estate that is smaller, you may be able to avoid probate, or you have a simplified process with the courts in California, where your estate, if it's under 166,000, you can avoid those sort of costly delays and things like that. So, and then the last thing about probate is a public process. So even if you have a will, your will get presented to the courts, and the will says everything. I have this asset and I'm giving it to this person. It's very public, so anyone kind of pulls up that information about that probate process.
Okay.
So that, keeping it private is something that's important to people. And in order to keep it private, you really can only do it through a revocable trust.
Oh, excellent. Thank you so much for explaining that. We do have actually a couple more questions popped through. Should I check with my parents to see if they have the documents that you mentioned? And what if they're starting to have memory issues?
That's critically important, very important. If your parents don't come to you to talk about estate planning, go to your parents and talk to them about that. And especially if they're starting to have memory issues. If there's any changes to their plan, if they're not of a sound state in mind, that could be a problem if they try to go in and update their estate process. So I would definitely go to them and ask those questions and keep asking until they tell you, so that you can help them.
Okay. Yeah, that makes a lot of sense. It looks like we have one last. Oh, actually, a couple. Okay, there's another question here. We keep hearing more and more about financial elder abuse. Does having an estate plan help to provide protection?
It could, and the way, and it depends on how you structure it. But if, for example, you have an estate plan in place and you have power of attorney for financial decisions, if they're becoming diminished in terms of their mental capacity, that could be determined, and at which time you can change the trustee or change in the financial power of attorney can jump in. So that could be important. You don't want to be in a situation where you force it to happen. It probably would be better if, for example, your parent says, I'm good being the sole trustee now, and then at some point you talk to them and say, hey, can I be, at what point do you think it makes sense, and talk to them before they have too much diminished capacity. At what point do you want me to be co-trustee? And then at what point do you want me to take over completely for your financials? Because obviously it's not going to be, one day they're fine and the next day they're not. It's going to kind of be a period of time of diminishing cognitive ability, but you definitely want to have that in place so that you're prepared, and you can make those changes when it's appropriate.
Oh, that makes a lot of sense. Thank you. Yeah, people can plan ahead. How does the court system decide who gets my assets if I don't specify someone?
Yeah, they have those rules in place. It tries to be as reasonable and as applicable to as many people's situations that make sense. But obviously, in special situations that we talked about, maybe having a second marriage, having a special needs child, in those situations, it's critically important. Otherwise, you can inadvertently exclude people from your estate plan that you don't intend.
Yeah, that makes, all right, great. Thank you. Oh, let's see, one more just came through. How long does it take for the heirs to receive assets if it goes through probate?
It could take like a year. It takes a long time, especially with the courts backed up, and how complex it is. It depends on how complex it is. If it's, again, under that 166,000 threshold, that's a simple process, pretty easy, straightforward. But if you're getting over that amount, it takes a long time, like 3 to 12 months it potentially could take.
Oh, so, really? Okay.
Yeah,
so people
it could be tied up for a while.
That's why people really, plan ahead or expect for that. Okay.
Yeah.
Great. Let me see if there are any other questions that have come through. I think looks like we're good. All right, Amy, thank you so much for taking all those questions at the end. That was really great of you to take them and be in the hot seat for that.
Oh, you're welcome.
All right.
Yeah.
I would like to remind everyone that if you missed any part of this presentation or if you would like to watch it again, it will be available on the Los Angeles Public Library's YouTube channel shortly. The link for that is www.youtube.com/Los Angeles Library. Please join us again for our future programs. We have a few more financial planning programs coming up on managing your savings. You can find information about all of our programs on our special Financial Planning Month website, which is lapl.org/financial-planning. Thank you again, Amy, and thank you again, everyone, for attending, and have a really great day and weekend ahead.
Thank you. Bye.